Welcome to David and David on Real Estate. Join us as we explore the ins and outs of the real estate market.
Good morning and welcome to the David and David on Real Estate podcast. And we are today on episode number 67. And today we have a very special guest. We have Brahm Siegel from Nathan Siegel, LLP, joining us today and talking about a very contentious issue and one that has very deep roots as well in real estate. And we are talking today about family law. Welcome, Brahm.
Morning, guys. Thank you for having me.
Very good.
Well, Brahm, it's great to have you on this podcast. There is so much real estate and family law that gets interconnected, and a lot of people don't realize that we get asked for referrals all the time for people, selling the matrimonial home, and we get retained by family lawyers to act as the neutral lawyer selling matrimonial home. But it's not just, when the marriage breaks down, there's all kinds of issues going into a marriage or going into a relationship. You have to consider your real estate and things like that. So we're really happy to have you on here because we got a whole list of questions to ask a real expert on family law.
Well, I'll do my best. Fire away.
Well, where do we start? I mean, Brahm, talk to us a little bit about the history of family law. Like, what should realtors be aware of?
One thing that comes up a fair bit is the business about the matrimonial home and what that is and how that impacts on realtors. Because a lot of people throw that term around without really understanding what it is. So the definition in law of a matrimonial home is the home that the parties were ordinarily living in at separation, that one party has an interest in. So a rental is not a matrimonial home because no one can have an interest in a rental. And, if something is a matrimonial home, there are three important things that flow from it. Can't sell it without the other side's permission. Can't encumber it, put any debt against it with the other side without the other side's permission, and you can't kick the other spouse out. And this applies whether or not the house is in joint names or not. So if the house is in joint names, of course, both parties have equal rights to the equity and all that. But if the house is just in one person's name, even if it's in that person's name, they can't kick the other side out and they can't list it. And so as a realtor, it's important for you to know if you're being asked to list a home, although you can go ahead and list whatever property you want, that home is not going to be able to be sold unless both spouses sign off, even if the house is just in one person's name. And that is often something I have to get into with younger real estate agents who don't know the law.
We have at my end also with clients, especially younger clients buying a property and deciding, whose name it should go in. And a lot of times it comes down to potential liability issues. So if you have a couple, even though both might be contributing to the purchase of a matrimonial home, sometimes it makes sense for it to go in just one person's name. Like, for example, I've never owned a home in my life. My wife has always owned our home. And the reason is because I'm in a business where I potentially could be sued and my personal assets could be at risk. So my house has always been in my wife's name because my protection, right?
Sorry, Dave, we missed that last time. Your protection is
the Family Law Act.
So yes and no. The Family Law Act basically says, if you separate, the way it works is we look at how much each person has increased their net worth, one over the other. So David, you're 100% correct that, even if you separated, God forbid, the house would be on your wife's side of the ledger, so to speak. It would be her asset and you would get half through the equalization or the property formula process. But things sometimes are not so simple because let's say you separate on May 1st and it takes 2 or 3 years to resolve your case. And after May 1st, your property goes up in value. If your wife says, you know what, that property was mine and beneficially or truly mine, any increase in that property also stays with me. You'd say, no. You were holding that property half for yourself and half for me. So therefore, any increase in that property should go to both of us, which is why it's a really good idea in cases like yours and other cases where parties are contributing equal amounts of money or even unequal amounts of money, but the property is only going in one person's name, to have a contract, even a short contract. Better to be prepared by a lawyer, of course, but if nothing else, even a one-page trust agreement saying, I am holding this property in trust for David Corman, or half this property in trust for David Corman. That will save you loads of time, effort, and sorus, as we say, down the road.
Well, I guess, just in case my wife happens to watch this podcast, which she doesn't usually watch
Which
anyway.
I'm sure she doesn't know.
Which she doesn't, but I should just put a disclaimer out there that we were 17, got married 5 years later at 22, been happily married for 41 years. So I'm just throwing that out.
David? You know what they say, the first 41 are the hardest.
Exactly.
It's all downhill after that. Sorry,
You're
divorce
the
lawyer joke.
Something tells me David Corbett has nothing to worry about.
Very good.
The point is, though, I can't be dispossessed. Someone in my position, not owning title, I can't come home and the doors are locked and I'm out because it's in her name. I have rights to possession. I have rights to get notice. The property can't be mortgaged or sold without me knowing about it. That's the protection.
Not without you knowing about it, without you consenting to it. And that's
without me consenting to it.
because it's a matrimonial home, or likely would be at the time of separation.
Right.
But if you have a condo in your own name and you've never lived there and you weren't living there at separation, that's not a matrimonial home, and you're free to do with that as you please.
And Brahm, the definition of matrimonial home, does it shift or does it move? Like, let's say that a couple are living in a home for 15 years and that's their matrimonial home, and
Yep.
then they don't sell it, they move into another property, and now they're living in that other property for 6 months.
Yes.
And now a realtor is contacted to sell that original property. Only one person is on title. Is that original property, because the parties have been living in it for the last 15 years, is that a matrimonial property?
The answer in your example is no, because the definition of a matrimonial home is the place that the parties were ordinarily residing at separation.
Gotcha. Okay.
Now, there's one other thing we should probably talk about, and that's what happens if the home at separation, the matrimonial home, is the same property that one person owned at marriage. Notice I said one person. If you both own it jointly at marriage, it makes no difference. But the Family Law Act and the regime that we talked about with this, looking at the increase in the net worth, we call that equalization. It works pretty well, except for one problem. Some people believe it was an error in the drafting of the legislation. Other people believe it was not an error. But basically, the law says that if you own the matrimonial home at separation, and that same person owned the same home at marriage, you do not just look at the increase in the equity, which is what the law says about all other assets. You basically treat the equity at date of marriage as a zero, which means whatever the equity is at separation, the other spouse gets the entire 50%, regardless of what the equity was on date of marriage, which is totally unfair and makes no sense. And it's why a lot of people believe it was a drafting error. And it's the biggest reason why we do cohabitation agreements, which are contracts that people do when they are entering a relationship and going to live together, may marry, may not. And these cohabitation agreements can say lots of things, but in cases like this, the biggest thing you want to put in there is, if we marry and separate, I get credit for the equity that I'm bringing into this home at marriage, because otherwise you're not going to get it under the Family Law Act.
That's interesting.
It's
I
terrible.
wasn't aware of that.
Yeah, the way the Family Law Act works, and you'll correct me if I'm wrong, because I try and simplify it when I talk to clients. But basically, it's, when the marriage breaks down, there's sort of a presumption of whatever is considered to be a family asset is going to be split 50-50, unless there's an argument that either one makes where they can say, I'm entitled to more than that because I brought more into the marriage, or I did, or something, or certain of those assets shouldn't be part of that basket of assets. But the basic presumption is, what at the end of the day, after you've done all your magic, whatever's left that's considered a family asset is sort of split 50-50, unless there's a good argument why it shouldn't be 50-50.
So I think a better way of understanding how the law works is to think of a photograph. Think of a camera taking a picture. actually two pictures. We take a picture on the date of marriage, and we take another picture on the date of separation date. And the picture that we're taking on each date is what each party is worth. Assets minus your debts. Okay, you follow? And we take that picture on date of marriage and date of separation for both parties. And the law says what you have to do is you have to look at the increase in each person's net worth from marriage to separation, their entire net worth, real estate, corporate assets, stocks, shares, bonds, whatever. Now, if both parties increase their net worth the same amount of money, what do you think happens? Nothing happens. Zippo happens, right? Both parties go their separate ways. And if they own anything jointly, not every home is in joint names, remember, they split it and each get half. But usually in my cases, things aren't so simple. Usually in my cases, what happens is both parties increase their net worth, but one person's net worth goes up more than the other. Well, what the law says that what you do there is you look at what the gap is, okay? And whatever the gap is, this person pays this person a chunk of money to make life equal. And that chunk of money is called an equalization payment. And the reason that this is set up this way is because the law says that marriage is a partnership. So the idea is that everything accumulated during the marriage is factored in, and whatever the gap is equalized with that payment. That's a better way of understanding how it works. So there are no such thing as family assets, right? My RSP is my RSP. It's the increase, however, in my RSP during the marriage that's going to get factored into the calculations, and which my wife is going to get half of through the equalization payment. But on the other hand, I'm going to get half of the increase of her RSP. It's all going to be factored in to one number.
Right. So one party can have zero assets throughout their marriage. The other party can accumulate all the assets. That isn't the relevant factor. It's not whose name it's in. It's what happens when you go through this equalization process with the growth of it during the marriage.
Well, it does matter whose name it's in, because if it's in one person's name, their net worth is growing. They're the ones that are going to owe the equalization payment.
Right.
So in your example, David, let's say that you and your wife didn't have any trust agreement. Even if you didn't have a trust agreement and all the growth in your family's net worth was on her side of the ledger, her growth would be like this, your growth would be zero. She would owe you a very hefty equalization payment. So from that point of view, you're right. It doesn't matter. At the end of the day, the parties are both in the same boat. I understand what you're saying, but
right.
Whose name it's in matters very much in order to calculate who owes who.
To do the equalization, right. But once the equalization, that's the intention. But there's also, there's sometimes, I assume what you're arguing, Brahm, is that at the end of the day, it shouldn't be equalized.
I'm not arguing that. I'm just explaining what the law is. I'm not arguing.
Right. No, I'm just saying, but if you're acting for one of the parties, sometimes there's arguments to be made why that spouse should, why certain of those, that accumulation that one spouse had should not be equalized. Certain assets should not be part of what you're equalizing.
So the Family Law Act, the equalization scheme, is extremely strict and rigid and hard to get out of. And we tell clients that all the time. And it's actually a very good thing to be able to tell clients, because they want certainty. The last thing a client wants to hear is, well, on a Monday, Wednesday, or Friday, it could go this way. And a Tuesday, Thursday, Saturday, no one wants to hear that if you're paying big bucks for a lawyer. So equalization and the formula is very, very hard to get out of. There are, however, some exceptions to equalization in very, very unusual cases. I'm happy to share them with you if you're interested, but they're very, very rare exceptions.
And Brahm, I agree. I mean, I went through this process a couple of years ago, and you understanding these terms, understanding how some of these technicalities work was very eye-opening, but at the same time was also very reassuring that the system works and that it's fair to both parties, and that there is some certainty in kind of the whole process, right? And a lot of this process is very heavily anchored in disclosure.
You're 100% right, and you can't get anywhere in family law with a proper, binding, valid, enforceable settlement unless both parties have made full and complete disclosure. And a lot of people come to me with already the solution in their head. Maybe even have talked about it with their spouse at the kitchen table, and they just want to present me with the solution and have it all drafted up. And it sometimes is a bit of a task with clients to explain that doing that and going ahead and going right to a settlement is a recipe for having your agreement overthrown, overturned, and ignored by the courts. You have to go through the process, because unless there's been full, proper financial disclosure, sometimes these agreements are not worth the paper they're written on.
Yeah, so I'll share my experience really quickly, and I'm kind of an A-level personality, and I like things done a certain way, and my brain works a certain way, right? So when I'm present a really complex issue, a lot of the times in my head, I'm like, I already have the solution, right? And I think a lot of really type A personalities that are really driven function like that. So this whole process taught me that I need to step back and I need to let the professionals handle my case. And I mean the results were extraordinary. So it was a great process, but it was also a really great learning experience going through this process as well.
Yeah, I had a client in my office yesterday, and she's in the family law world. Let's say she's not a family law lawyer, but she's in the family law world. She's not a realtor, and we were completing her financial disclosure for a cohabitation agreement, a very, very simple, straightforward case. And she just looked so on edge. And at one point I stopped and I said, is everything okay? You just look so, you know, irritated or agitated. And she paused, she sat back, and she said, I guess I'm just not used to being on this side. So, like you, David, and you, David, she's in the service of providing information, providing services. It's very difficult when you're in the client seat, right? And have to take the instructions or take the advice, and you're the client. It's different.
Well, Brad, maybe tell us about, when you're talking about couples getting married, going into a marriage or into a relationship, and you're retained to do a cohabitation agreement or a prenuptial agreement.
Yeah.
Like, I found that to be a difficult process for a lot of people to wrap their heads around, because you're going into a relationship negotiating the breakdown of the relationship. So how do you approach it with clients, to get them to understand this is a good thing for them to do, and how they should not try and kill each other as they're trying to negotiate this?
Well, first of all, you say it's a good thing to do. It may not be a good thing for someone to do. So if you're a 27-year-old woman, never had kids before, and marrying someone, it's your first marriage, and you have no nest egg in your bank account, there's no good lawyer around that I know that's going to advise that woman to sign a prenup, giving away her rights to spousal support or equalization. It's just not going to happen. So a cohab or a prenup, which allows you to restrict or waive spousal support or equalization, which we've talked about, is not for everyone. Usually in second marriages where both parties have been through the system or the ringer, depending on how you look at it, the first time, and they've made all their disclosure and they've mediated or settled the case, and they both have assets, they both have significant means. Those cases are much easier to stomach why someone would want full releases and waivers in the event that they separate or break down. But we spend a lot of time when someone comes in saying, my fiance wants a prenup, talking to them about what the law is and whether or not it's a good idea for them.
Yeah, like, to me, it's sort of more obvious, when it's a second marriage and they've accumulated assets. The times that I've found it really hard is when it's a first marriage for a young couple in their 20s who are just really starting their life together. They're just, they're going to build their life together. But one comes from a family where there's a lot of money and a lot of potential inheritance and things like that. And there's pressure from the family on one of them to get a prenup to protect them in case the marriage breaks down. Oh, we love you, love you. But just in case your marriage falls apart in 3 years, we want to protect our child who's going to have all this inheritance and all the money. How do you deal with that?
I deal with that all the time. And there's many, you could spend a whole podcast just talking about those kinds of prenups. Of course, the major thing is disclosure, right? Usually the family doesn't want to make disclosure if there's a trust, a family trust that owns lots of assets. And I always tell them, if you don't make disclosure, you're putting the contract at risk. So disclosing the net worth, the underlying assets of the trust is always better for you, better for the family, because it means the contract will likely stand up. And I almost always have spent a fair bit of time with the client, the other lawyer. We have a bit of a process where we'll do a four-way meeting or a negotiation after all the disclosure's been made on exactly what they want to do here. Often the young woman will say things like, I'm not interested in his family's net worth. Well, it can get a bit complicated because the family's net worth can get mixed in with his net worth. And remember, his net worth, if it increases during the marriage, he's entitled to half. So having specific and clear language in the contract that spells out how his net worth is going to be differentiated from his family or his family's corporation's net worth, that takes a bit of time and effort, and especially if there's different assets, different companies, but it can be done. But again, unless the woman in this example that you're giving, unless she has independent means of her own, I don't know any lawyers that are going to recommend that she gives up all of her spousal support rights. She may agree to restrict them, or may agree that for purposes of spousal support, only these items will be considered when it comes to income from the husband. Perhaps maybe they'll agree that any trust distributions he get are not part of his income for spousal support, and it's only going to be his employment income or his employment and investment income. There's all kinds of things that you can do in a negotiation in that regard. But giving up your spousal support rights when you're marrying into a wealthy family completely, I don't see any good lawyer recommending that.
Your
Think about
challenge is to navigate and negotiate through that without affecting the relationship of this couple that really wants to, to build a life together.
Yeah, I've had a few cases over the years, not many, where the process itself led to the breakdown of the relationship and the marriage did not take place. It happens.
Yeah, but Brahm, my argument would be like if your relationship is not strong enough to have those conversations at the beginning, then it probably wasn't strong enough for you to enter into that relationship in the first place.
Correct.
I mean, that's the only conclusion that you can make. And one thing that stood out to me, and I will never forget this conversation that you and I have had, is I was talking about one of my issues to you, and you just looked at me and you're like, David, nothing that you're telling me is going to be interesting or different from any other client that I've dealt with 1,000 times. Right. And to me, that gives me reassurance, because it tells me that, these personal finance issues are very complex, but you deal with these complexities on an everyday basis.
Yeah, I mean, there's a fine line when you're in this business. You don't want to come across as not being sympathetic. You don't want to come across as not being someone who doesn't listen to your clients and doesn't understand their particular needs. Having said that, there are some very clear criteria for what's relevant when you're talking about child support, spousal support, property, and sometimes the detail that you get from a client is not going to impact on that. So it takes a bit of a bedside manner, I guess, to gently explain to clients. And some of us do this better than others. And sometimes I do it better than other times, I guess, depending on my patience and time commitments. We explain, this may be very interesting to you, but when you go in front of a judge or when I'm dealing with the other lawyer, these are the things they're going to be looking at. And that's what you try and do. It's a bit of an education with the client as you move forward.
Yeah, 100%. So let's talk about family law as it relates to realtors. And Brahm, you came up with an amazing list of questions and topics to discuss. And number one on the list is securing financing and buyouts.
Yeah, this is not so much to do with the agent, but when parties are separating, if the house is in joint names, very, very common experiences for one to try to buy out the other. And I always explain to clients that even if you're offering an amount for the buyout, that's more than what the property's worth, right? You can get it appraised by an appraiser or a realtor. Even if you're offering more, there's no guarantee you're going to get that buyout for two reasons. One, judges do not have the power to force someone to accept a buyout, even if you're making an offer that is better than what it's worth, right? So the default is always a for sale sign on the lawn, always. So the person who wants the property sold always has a bit of an advantage, and the person trying to buy the property, sometimes, if they really want it, winds up paying a premium to keep it off the market. The second issue is, even if the parties agree on the price for the buyout, if there's a mortgage on it, the deal will not happen unless the bank agrees to take the person who's coming off title off the mortgage. And that depends, of course, it's a function of whether the person retaining the property is able to get the necessary financing. And so you have to be very clear when you're doing these deals, how that works. I always put in, if I'm representing the wife, let's say, who's being bought out, I always put in a clause that says this whole transfer is conditional on her being removed from the mortgage. And 10 days prior to the transfer, the husband and his lawyer have to provide us with something from the bank. I don't want something from him. I don't care about that. I want something from the bank confirming that the husband has been pre-approved for financing sufficient to remove the wife from the covenant of the mortgage. And if he doesn't have that and he can't close, I always put in the property is going to be sold. So that's the incentive that we put in for the person who's getting the property, the transferee, go and get that financing.
And
Yeah,
you're
you
thinking
need a
ahead,
release.
you're already setting up the moves for, if this doesn't happen,
Yeah.
then we have consent and it's mutual and we don't have to go through another legal process
Correct.
to the next step, which is really smart.
Correct.
The key is getting that release from the lender, and the party buying may not have a strong enough covenant to carry the mortgage or bill themselves. Sometimes they have to go and get another relative or somebody else to sign on and go on title with them, really as a guarantor for that mortgage in order to allow that to happen. But from the party that's getting off, they need a clear release that they're no longer responsible for that
And
mortgage.
that's even more of a challenge. You guys know about this better than I do, but in November 2022 compared to November 2021, it's much harder for people to get that financing with interest rates, isn't it?
100%.
That they may be discharging a mortgage that had a really favorable interest rate and refinancing it now with the spouse that's going to be acquiring the property at a much higher interest rate that's not as affordable.
Yep.
That's not fun. Graham, the other issue that, when we're talking about financing and buyouts, from a real estate point of view is, where do you secure the money for a down payment on a property that, the spouse that's moving out of the house and they want to buy a house? How do they go about securing the funds to put down on the property that they're buying and be able to come up with the down payment? If there isn't an amicable situation, and let's say there are no funds outside of the matrimonial home.
I always tell my clients who are in that situation, do not sign an agreement of purchase and sale that closes on the same day as your transfer to your spouse, because that property may not close for all kinds of reasons. And now you're stuck with an agreement of purchase and sale that you can't close. So I always tell them, find a place to rent or live with your parents, wait till the money is in your hot little hands, and then start searching.
Very smart.
Yeah, unless they're able to arrange a bridge loan or something, but they have contingency because there's a good chance it's not happening on the same day.
Correct. And the other thing, the kind of flip side, if I just made the flip side is this, is that if I'm representing the transferee, right? If I'm representing the husband who's getting the property, and I understand that the wife, for example, has already gone out and made a commitment and signed an agreement of purchase and sale that closes on the same day. And if the negotiations are not completed, I'm going to use that to my advantage, right? In order to extricate, to get my client the best deal possible, knowing that she's not going to want to get out of that new deal, and she's going to want to close.
Yeah, absolutely. Brahm, how do you select the agent? How do you encourage parties to select the right agent to help them through their real estate needs in these situations?
So the first thing I do is I'll talk to the client about when did they purchase the house, and if it's a fairly recent purchase, often they'll recommend the agent that helped them get into the house, especially if it's jointly owned. Sometimes, however, the other side doesn't agree for whatever reason. The agent has become friends with one of the parties. The agent's an alcoholic. The agent, is only working part-time. There's all kinds of reasons why they may not agree. So some of the tricks we as lawyers and mediators use include, the most popular one is one person comes up with 3 or 4 names, sends those names through counsel to the other side. The other side has a week or 2 to vet the names and choose one of them. And what I do when I'm mediating or arbitrating is I will put some criteria on those names. So I'll say that those names have to be people who are at arm's length from both parties and the lawyers. So it can't be like the lawyer's niece or nephew. 2, it has to be an agent who works full-time. I don't like dealing with agents who dabble in this industry. And 3, it has to be an agent who has an office in the area, meaning someone who's familiar with the area, right? I have a case now where the property's in Gormley, and the parties are talking about hiring an agent at Young and Shepherd. Well, I wanted to make sure it's an agent who's familiar with the real estate market in Gormley, right? So that's a very common technique. And of course, the final thing is Sometimes when I'm the arbitrator, I'll just say to the parties, okay, you've had 2 weeks to try and agree on an agent. Haven't. Each of you give me 3 names and I will vet the 6 names and I'm going to select one. And as your arbitrator, and I know we haven't talked about mediation and arbitration, but as arbitrator, I'll decide. And that's it, like a judge.
And what the rate goes into that. One side is saying, hey, I got an agent that can do this and they'll only charge a 1% commission because they owe me something or whatever. And the other party says, I don't care. I'd rather pay. I want an arm's length agent, and what we're going to offer the full 5%, 2.5% to each side or whatever, because we want it to be an arm's length process.
Yep. Sorry. I didn't catch. What was the question? Is that a relevant consideration you were asking?
Yeah. How do you deal
it's relevant.
with that negotiation on the commission rate?
Yeah, sure, it's relevant. Sometimes you'll find that one person has a big objection, but then if the agent who really wants the deal is prepared to lower the rate, all of a sudden those objections, about being too close to the other side and all that, and not being a full-time agent, sometimes those objections kind of fall by the wayside. And sometimes they don't.
Right. Brahm, the next item on the list is notional disposition costs.
Yeah, that's a big issue. So when a property is sold, as you all know, the agent gets their commission right off the top. But when there's a transfer, there's no agent involved. It's just done through the real estate lawyer and the family lawyers. So why are we talking about disposition costs? Why are we talking about agent fees? And the answer is because at some point in the future, we don't know when, the transferee, the person who's getting the property, is going to have to dispose of the property. And in all likelihood, they're going to have to spend some money on an agent. So because that is uncertain as to when that's going to happen, courts will typically suggest and give the transferee a bit of a deduction for notional disposition costs. But because they're notional, you don't get 5%. So on a transfer, it's typically 2 or 2.5%.
Any other fees included in that amount?
Sometimes people put in HST or half the legal fees and stuff like that. Again, it's heavily discounted, so it usually doesn't amount to a lot. But when I'm doing a transfer, I'll put in, whether I'm acting for the transferee, the transferor, even if I'm acting for the person, giving up their share of the property, I will agree to taking off 2 or 2.5%.
Awesome. Next item on the list, we have appraisals versus realtors. This should be an interesting topic.
I mean, you're a realtor, David, so you have your own views on this. The consensus in our industry is that judges prefer appraisals, the 20 or 25-page appraisals that you pay anywhere from $700 to $1,500 for by an AACI appraiser. Having said that, in many of my cases, people settle issues about what the homes are worth through discussions with realtors that they trust, realtors who do drive-bys, realtors who do comparative market analysis and all that. But push comes to shove in highly contested cases, judges they prefer, these appraisals done, which sometimes people think are a bit lower in general than what agents are prepared to put a property at, but that's what judges typically prefer. Again, not every case winds up in court, and people are free to come up with their value any way they wish. But it's always good to know what a judge is seeking in the event you don't settle.
Yeah, and I mean, I guess sometimes there's a big contentious issue between, letters of opinion and appraisals and what parties feel that the property's worth. And it makes a big difference in the bottom line to the net equalization payment and what that bottom line looks like. So I can only predict that there's a lot of conversation surrounding the valuation of investment properties and assets within somebody's portfolio.
But wouldn't you agree as an agent that a letter of opinion doesn't have the same sort of homework and depth and inspection and work that went into a proper appraisal? Wouldn't you agree with that?
Absolutely. That's why it's called a letter of opinion versus an actual appraisal that has a lot more substance and a lot more research and a lot more intent behind it.
One thing that your listeners or watchers may not know, which is a very important consideration, is just because you have the property appraised doesn't mean you have to disclose that appraisal to the other side. So if my client is the only one in possession of the home, the other side isn't in possession, my client gets it appraised, doesn't like the appraisal, I don't have to disclose it to the other side. I only have to disclose it if I intend to rely on it. And that's a really big piece to remember.
Interesting. Okay, I was not aware of that. That is a very interesting piece of the puzzle.
Yep. Now, if both parties are in possession of the house and I send over an appraisal and the wife is there and meets the appraiser, and then they never get the appraisal from my office, they put two and two together and realize, oh, they didn't like the appraisal that they got, but they don't have the right to demand it.
Very, very interesting. Let's talk about buyout versus sale.
Okay. What do you want to know?
Elaborate on those two.
So as I mentioned earlier, buyout is the default. A buyout is not the default. A sale is the default. If you can't agree on a buyout, it's going to be sold. Now, if the case is in court and the case is fresh, the judge is not going to order a sale ASAP. They're going to give time for the kids to finish their school semester. They're going to give time for a buyout to take place. They're going to give time for one person who says he wants to try and qualify for financing the time to do that. But if the separation has been going on for a long time, 1 year, 2 years, 3 years, parties have tried to settle, tried mediation, no agreement on buyout, a judge is going to order that property sold faster than, say, real estate commission. So that's basically how it works. And as I say, the person who wants the property sold always has the advantage. If the person really, really wants to keep and retain the house, they often wind up paying a premium. Now, one thing that I'm not sure if your listeners or watchers are aware, but in the event the property does go on the market, 9 times out of 10, courts will allow both parties to bid on the property. So it gets very sticky because the parties, husband and wife, have an agent, but then the person who wants to bid on the house, let's say the husband wants to bid on the house separately, he needs a separate agent of his own. And he can't have the agent that's representing both parties also represent him. That's a conflict of interest. So you can imagine how sticky and messy it gets. But judges in that scenario do have the power to say, this property's been on the market for a few months. The best offer they got was this. The husband came in with a much better, cleaner offer. And so we're going to dispense with the wife's consent so that the property can be sold to him on the open market through this mechanism. But it first has to get exposed to the market.
Yeah, I think I don't know if all the people watching or listening will really appreciate the type of process you go through every step of the way. You talk about, a judge might find this or a judge might find that. But before you get to a judge, you're having a negotiation with the other lawyer. Yes. You're going back and forth. One party wants a buyout, the other wants to sell.
Yes.
Trying to negotiate it out. But through this whole divorce process, you're running back to court many times a lot. Just settled one particular issue to get a judge we tried to negotiate, we hit an impasse, now we need a judge to force this one way or the other. It's an expensive process.
Which is why I'm glad you mentioned that, David, because in recent years, I'd say in the last 10, 15 years, we see a very, very big increase in people using mediation and arbitration as a way to resolve their case instead of the courts. And mediation and arbitration it's a private process where you agree to it, you can't be forced into it, and you're basically picking someone to be your problem solver, that's the mediator, and in the event that your mediator is not able to resolve your issues, giving that same person the power to make the decision. So it's basically a one-stop shop. It's very efficient. It's not for everyone. It can be expensive because unlike a judge who's free, you have to pay the mediator arbitrator, but the flip side is, generally you don't need to see that person very often. Can spend one day with them and get everything done in one fell swoop if everyone is prepared, has all the disclosure, and the mediator is top notch.
Yeah, and I mean that's kind of like giving the reference of private healthcare versus public healthcare, right?
100%. The system these days is very much like public versus private healthcare. So people who have the resources and decent lawyers have access to all these private mediators and private decision makers. They keep their case out of the court system, so it's confidential, and they get swift justice, swift resolution. And people who don't either choose not to or don't have the resources, there's still the court system, which is okay, but it's not nearly as good. Judges change all the time. You don't get to pick your judge, so you might get a judge who dislikes men, who dislikes women, who's having a bad day, going through a separation themselves, and that's very, very unfortunate if you're in that sort of position. So I always prefer, as much as possible, unless the circumstances dictate otherwise, to try and get my clients a resolution outside of the court process.
Brahm, you just mentioned something pretty significant. In your high-profile cases, is a big consideration for the person who actually has money to stay out of the court system simply for the disclosure and the public aspect of going into a court system?
Yes, huge.
So if you're the other spouse, would you not want to push to go into court to ruffle some feathers and to maybe get more of what you want?
Yes, but court is much, much slower. It's not uncommon that in the Newmarket court, the Oshawa court, Toronto is a bit way more efficient. But in Newmarket and Oshawa, it's not uncommon to wait 6 months, 6 months for a first court date. Whereas if you have a private mediator arbitrator, you can get a date within a couple of weeks. So most of the people in the situation you're describing, David, they want spousal support. They want child support. They don't want to wait 6 months for it. So there are some pros and cons of mediation arbitration, and it's important to talk to your lawyer about your particular case because not every case is well suited.
Wow.
Okay, and Brahm, you're dealing with the law and the process of Ontario and property in Ontario for the most part, but people do own assets outside of Ontario, whether it's other parts of Canada or other countries. So how do you deal with foreign owned property?
That's a really good question. So Ontario courts have no jurisdiction to make orders about foreign-owned property. So an Ontario court has no power to say, I'm ordering the sale of this property in New Zealand, and you're going to hire this agent, and you're going to do this and that. That is just, there's no jurisdiction for that. I mean, they can make that order, but it's not enforceable. On the other hand, there is some case law that makes it clear that courts in Ontario have jurisdiction over the people of Ontario. So sometimes you see judges trying to get around that by saying, well, we're not ordering the property in Florida to be signed, but we're ordering the parties in this case to cooperate to list the property for sale. That's a slight difference that judges sometimes use to get around that. In Latin, we call that a difference between in rem and in personam orders. In rem orders are orders about property. In personam orders are orders about people. Obviously, the best solution is a negotiated one because there's always a risk. A judge might say, I'm not ordering the sale of this property, and now you're stuck with it.
But the owned property, the foreign owned property has to be part of the equation in terms of disclosure and equalization. Like the value of the property has to be disclosed and part of the process that you deal with in Ontario.
100%. Yeah. Any asset, whether it's real estate or not, that's out of Canada forms part of the equalization process, which means you have to establish the value at date of marriage, if there is one, and a date of separation, and the increase gets factored in and the other spouse gets half through the formula. Correct.
Right. So, I mean, there is a mechanism where that property doesn't really have to get sold, especially
Correct.
with one person's name, but, the people in Ontario just deal with it, through the net equalization of
Correct.
process.
If I own a property in Sri Lanka and I owned it at marriage and I own it at separation and it's my property, there's no trust claims, it's not in joint names. No one can force me to sell it. No one. It's my property, right? You can only get a property sold if you have an interest in it, right? Through trust, claim, or on title. So it's just a question of me providing the value for what that property was at marriage and at separation, and the increase goes in to the equalization.
Wow. My mind is blown, Brahm. Like, I love the law, and there's so many different facets to the law, but family law is very special in the fact that there's so many different complexities, and you're dealing with so many different facets of people's lives to really try to kind of navigate. But ultimately, the biggest thing that it kind of aims to do is to protect the weaker person and the child in this whole complex situation. So realtors, dealing with these issues, they also have to be very careful. They have to know the basics of the law, and they have to rely on professionals to help them through these situations. But there's so much to consider when you're a realtor navigating these complex situations. I know we have a couple minutes, but give us 3 things that realtors should really keep in mind and some best practices when they're dealing with clients that are going through this process.
Really important to treat the parties equally. So even though the realtor may like one party better than the other, or one person's more of a pain in the butt than the other, it's really important that the realtor treat the parties equally, giving them the same information at the same time, and in high conflict situations, copying the lawyers on it, because it's not hard for agents to be drawn in. And next thing you know, in a high conflict situation, one party is alleging that the agent is skewing things from the other, even though almost every agent that I've ever met has no interest in taking sides. Every agent I've ever met is just interested in getting maximum value for the property. And the other thing that I would say, the final thing, I'll leave it at this, is that using a family law lawyer is a lot, to me, like going to a mechanic. So I don't know about you boys, but I don't know anything about how a car works. I've been driving one since I was 16, but I have no idea how a car works, and I'm terrible at things mechanic, and I can't put anything together at all. I'm terrible at that stuff. So when something happens to my car and I go to a mechanic, and the mechanic looks at me and says, well, you need a new this or a new that, and it's going to cost you this much, I just shrug and I go, I don't have any way of benchmarking that. I don't have any way of knowing whether he's telling me the truth, whether he's snowing me, whether he's giving me a good deal or a bad deal, because I have no reference point. And people going through the process first time, when they're dealing with family lawyers, realtors, appraisers, that's how they are. They feel vulnerable. They feel like, I don't know. I've never been through this before. I hear that all the time. I've never been through this before. So as a result, it's so important for them to get a good referral to a real estate agent that is trustworthy, knowledgeable, provides good service. And the same goes for a family law lawyer, because we've all heard of stories where someone went to a lawyer or an agent and didn't know and put themselves in their hand. And next thing you know, they spent $60,000, $70,000 in legal fees they didn't need to spend because the lawyer was more motivated about turning the file or didn't have good judgment or whatever. So getting a good referral from someone you trust, whether it's a real estate lawyer, real estate agent, or a family law lawyer, is so important. And I always think about the car mechanic example in that scenario.
Well, that's a great way to put it, Brahm. And we have so many more questions. I really hope we can reschedule and continue this, because we covered a lot of ground, but there's so much more that I think real estate agents, other people in the real estate industry would really like to know and learn. So I hope we can put this together and do another session. Thank you so much for your time today. This was some fabulous information.
Thank you so much for having me. I'm glad I did this. Thanks so much, guys.
Pleasure. Thank you, Brahm.
All right. Bye-bye.